Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 119 of BSA Act 2023. Corresponding law section is 114 of Indian Evidence Act. This video is about part 2 of burden of proof cases. Court may presume existence of certain facts. The court may presume the existence of any fact it thinks to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. Examples: the court may presume that a man who is in possession of stolen goods soon after the theft is either by the thief or who has received the goods knowing them to be stolen unless he can account for his possession. Second one is that an accomplice is unworthy of credit unless he is corroborated in material particulars. Third one is that a bill of exchange accepted accepted or endorsed was accepted or endorsed for good consideration. Fourth one is that a thing or state of things which has been shown to be in existence within a period shorter than that within which such things or states of things usually cease to exist is still in existence.
Many court cases have fallen in this illustration. Fifth one is that the official acts have been regularly performed. Sixth one is that the common course of business has been followed in particular cases. Seventh one is that if a man refuses to another a question which he is not compelled to answer by law, the answer, if given, would be unfavorable to him. That evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. Ninth one is that when a document creating an obligation is in the hands of the obligator, the obligation has been discharged. Very important illustration, that when a document creating an obligation is in the hands of the obligator, the obligation has been discharged. More discussions. Accused unable to explain the presence of dead body inside in his house, court may presume his guilt.
Next, acquisition of property by a Hindu, whether for his own benefit or the benefit of joint Hindu family. Burden to prove the contrary is on the one who claims purchase to be for benefit of all. Suit for partition. Account books in possession of defendant not produced. Adverse inference can be drawn against defendant even if inspection and production of account books was not demanded. Adverse inference. Party failing to appear in court, question of drawing an adverse inference would arise only when there is no other evidence on record. Defendant deliberately not producing material documents in his possession adverse inference can be drawn against him, though onus of proof was on the opposition or opposite party.
Adverse inference may be legitimately be drawn. All acts and things are presumed to have been rightly and regularly done. The presumption, however, is one of the fact. It is an optional presumption. Original or stable honors laid down by section 104 and 105 of BSA Act. Corresponding law section is 101 and 102 of Indian Evidence Act cannot be shifted by the use of section 109 of BS Act. Corresponding law section 106 of Indian Evidence Act. Although the particular onus of proving facts and circumstances lying especially within the knowledge of the official person. Diverse petition on ground of impotency. Refusal by one of party to get medical examined. Court entitled to draw adverse inference. Adverse inference against prosecution not to be drawn for failure to examine another person. Most important point this is. Section 2L and Section 118 of BSA Act. Corresponding law section is Section 4 and Section 114 of Indian Evidence Act. Distinguish between presumption of fact and presumption of law. Most important topic. Presumption of fact are inferences of certain fact. Patterns drawn from the experience and observation of the common course of nature, the constitution of human mind, the springs of human action, the usages and habits of society, and ordinary course of human affairs. Whereas Section 118 BSA Act, corresponding law section 114 of Indian Evidence Acts, dealing with existence of certain facts in the court, may presume adverse inference can be drawn on certain cases. It is the judge discretion in each case to decide whether the fact with which under section 118 of BSA Act, corresponding law section is 114 of Evidence Act, may be presumed has been proved by virtue of that presumption. Example, res ipsa loquitur.
Example, res ipsa loquitur. The thing speaks for itself. It means the thing speaks for itself. In accident cases, three conditions must be met. One is, the incident did not occur normally without negligence. Second one is, the object, that is, tool that caused the accident was under the defendant's control. And third one is, the victim did not contribute to the accident. Section 109 of BSA Act, corresponding law section is 106 of Indian Evidence Act, explains the burden of proof as to the particular fact. Res ipsa loquitur, the doctrine is codified under this section, which shifts the burden of proof to the defendant in certain negligence cases.
This video is purely theory. The Honorable Court decides each case on merits.
Thank you.